Public Safety, 23rd meeting of the Public Safety Committee, and we are inquiring into pursuant to an order dated October 8th, 2020. We're studying the parole, a study on the parole board and the circumstances that led to a young woman's death. I'm sure that colleagues by now know the protocol with respect to this hybrid meeting, so I won't repeat that. We have two witnesses today, two sets of witnesses today. The first hour we're dealing with Michel Laferniere, and the second witness in the first hour is George Mayette. Each has 6 minutes to present. Sorry, 7 minutes to present, and I don't see any particular order, so we'll just go with Mr. Laferniere for 7 minutes, please.
Est-ce que je peux commencer tout de suite?
Can I start now? Yes, please, go ahead. Good afternoon, everyone. I'd like to thank the clerk, the chair, and the members for giving this opportunity to speak to you. Interpreter apologizes, but the sound has just started to cut out.
Mr. Laferniere, we're seeming to have audio difficulties.
Oui.
I need guidance from the interpreters.
It's very warbly sound. That's what I'm getting. I'm not getting a clear sound at all.
Vous avez des difficultés à m'entendre?
Warbly to the extent that we can't proceed with Mr. Laferniere, or should we maybe go to the next witness, Mr. Mayette, and see whether in the meanwhile the technicians can help Mr. Laferniere improve his horn. Okay, is that all right with you, Mr. Laferniere?
Yes, that's fine. Thank you.
Okay, Mr. Mayette?
Yes, I'm here.
Oh, good. Okay. 7 minutes, please.
Okay, I'm going to read a prepared statement, and hopefully I can keep it within the 7 minutes. I appear here today as a proponent of parole and its use as part of the reintegration process for incarcerated persons. I wish to acknowledge that the death of, if I say this properly, Marilyn Levesque, was an unfortunate and terrible tragedy, and I wish to express my sincere condolences to her family and the community. I have been a professional and a volunteer in the criminal justice system since 1973, and have personally counseled inmates in their parole preparations many times through my involvement with the 7-step self-help groups, which are designed to teach accountability and self-awareness as offenders work their way through the system. Our institutional self-help groups use confrontation and support to assist inmates to develop realistic release plans, and once released, provide community support groups comprised of successful ex-inmates and community volunteers, where the parolees can return on a regular basis to discuss challenges and successes in their lives. I myself am a former offender, having been convicted of several offenses as a young man, and after having successfully completed a parole, continued my education to graduate from Mount Royal College in Calgary in 1975 with a diploma in criminal justice. I was subsequently involved with the development of community residential centers and contract parole supervision through the auspices of the Alberta 7-Step Society in conjunction with Alberta Corrections and the then National Parole Service. I received a pardon in 1980 after the appropriate eligibility period and considered this as a positive milestone in my life. I chose to leave employment in the criminal justice system in 1982 to pursue a career in the oil and gas business, but continued as a volunteer board member and self-help group member thereafter. I assumed the role of volunteer executive director of the 7-Step Society of Canada in 2002 and continue in that role today, as well as sitting on the executive committee of the National Associations Active in Criminal Justice. I was fortunate to have a successful career in the oil and gas business and was able to dedicate my time and expertise within the criminal justice system with no need for compensation. During the past 5 years, I've been an active volunteer at William Head Institution on Vancouver Island, where our 7-step institutional self-help group was primarily comprised of inmates serving life sentences for murder. All of our members were actively working on a release plan as they neared their parole eligibility dates. They were not always successful in their first or even second attempts, but with perseverance and cooperation with their case management teams, along with their own personal development and accountability, our members were able to gain a release to the community and are contributing members of society today. Of our 8 original group members, our last active member was released on day parole to a CRF, or community residential facility, in Victoria this past September, and we are planning for a new group to start up once the COVID restrictions allow. This tells me that a system of supervised release is an important and necessary part of the reintegration process. I fully support the mandate of the Parole Board of Canada and do have some knowledge of their selection of board members, having acted as a reference for 2 people who had applied for part-time parole positions in the past. I understand the selection process to be quite rigorous and extensive, and with extensive training once a person is selected. I know that the parole board members are charged with an onerous responsibility in administering decisions regarding release on passes, day parole, and full parole. I do not interact directly with sitting parole board members, but do have feedback from the inmates who appear before them and know that the hearings are intense, in-depth, and thorough. As a citizen and a member of the community, this gives me a sense of comfort knowing that in addition to the professionals and volunteers working with offenders in the system, there is an oversight body that makes the final decision on gauging an inmate's suitability for release into the community. Once the decision to release an inmate has been made, the responsibility for supervision in the community then rests with the Parole Service, or CSC, and although the final responsibility still rests with the Parole Board, the direct supervision is handled at a community level. I have read the Board of Inquiry report regarding the release, and I hope I say this right, Eustachio Gillespie, and his supervision in the community, and believe that the tragic death of Marilyn Levesque was an anomaly, but cannot judge if it could have been predicted, since I'm not a psychiatric expert and know nothing of the personality of the offender. If warning signs were overlooked or ignored, this is obviously very concerning and needs to be addressed. I can only say that in my previous experience as a contract parole supervisor, albeit many years ago, there was very good communication and accountability between our agency and the Parole Service with regards to each case that we supervised, as they had the ultimate responsibility for the offender in the community. I do not believe that contracted parole supervision presents an undue risk to the community if proper protocols are followed and there is clear communication in all directions. In this specific case, engaging from the Board of Inquiry report, there is some ambiguity as to how the direct supervision of Mr. Gillespie was administered, and hopefully, if there were gaps, they will be closed in the future. It is not for me to assign blame in this case, since I only have a peripheral understanding of it. I can only state that predicting human behavior is not an exact science, and in many respects, but with adequate assessment and preparation, proper supervision, and follow-up with clear communication, the chances of this happening again is unlikely. My recommendation—
1 minute, Mr. Mayette.
Thank you. My recommendation is that this one tragedy does not become an event that unduly affects a highly effective parole release system, but serves as an opportunity for improvement and increased security for the community. Thank you for your time, and I welcome any questions.
Thank you very much. Mr. Lafreniere, I understand your internet connection has been restored. 7 minutes, s'il vous plaît.
6 minutes, please. Thank you. Thank you very much, Mr. Chair and members of the committee. Thank you for giving me this opportunity to testify before you. My purpose is to offer some solutions with respect to the system and society. I'm testifying today as an individual, and also I'm a former commissioner of the Parole Board. I began my career back in '69, and the interpreter apologizes, but the sound is cutting out again. It's
Yeah, apparently we've got more difficulties.
Ouais.
I'm not quite sure what to do here, given that this is an
Mr.
unstable
Chair.
connection.
C'est
Mr.
le-
Kirk? Mr. Kirk, did you have a point of
malheureusement,
order?
quand on a fait le-
Yes, a point of order, Mr. Chair. Maybe the witness could turn off his video for the statement where we've secured his identity. That might allow for the bandwidth so that we can make sure that we hear his statement in both
je
of
peux-
Canada's
je peux
official
l'essayer.
languages.
That's worth trying, certainly.
OK, je vais essayer d'enlever la vidéo. Bon,
Okay,
j'ai
you're
enlevé la
off.
vidéo. Est-ce que
Okay.
ça fonctionne mieux?
we'll see if that works better. What I was saying, I don't know where the connection cut off, but I was talking about my career, and today I'm testifying as an individual, as a retired lawyer, but I'm also a former commissioner at the parole board, and I began private practice in 1977, and then I was appointed as a part-time commissioner. I continued with my legal practice as well. I later was appointed full-time for a 5-year period as a commissioner. So the first part of my career was at the National Parole Board. I spent 10 years there. Unfortunately, in 1996, I was not reappointed, despite the fact that the performance review said that I had superior performance. I continued my career at the Correctional Service. I was responsible for the legal training of parole officers, and I trained emergency teams. I spent 11 years at the Correctional Service, and in 2008, I applied to become a commissioner at the National Parole Board. I was hired in 2013 for a 5-year period, which came to an end 5 years later. So I have 20 years of experience at the National Parole Board and 11 years of experience with the Correctional Service of Canada. And in addition, I've been in private practice. When my mandate came to an end in 2008, I wanted to work part-time. I was 66 at the time, and I felt that I could still continue working as a commissioner, particularly to help those new commissioners, to share my knowledge with them and act as a mentor. I applied. I passed a test. I did a test, but I never got a response. And I understood at that time that my term of office would not be renewed. What I've noticed is that the board is an organization that is wonderful. It gives very interesting results. It's just about the only organization that's not able to keep on board the most experienced members. And it's always having to hire new commissioners. It becomes a revolving door, and it looks like people are disposable. I'd like to talk to you about what happened recently in 2015. From 2015 to 2017, there were no renewals of mandates for commissioner positions, which led to a scarcity of commissioners and an increase in workloads. And I can tell you that security or safety was kind of set aside. There was a massive influx of new commissioners in 2018. Of course, the board has a good training plan for new commissioners. 2 weeks in Ottawa, several weeks in the region, but this is basic training, and then there's experience that you learn on the ground and on a daily basis. I think it takes between 18 and 24 months before a commissioner is really comfortable with a system and is independent. Usually, new commissioners are trained or twinned with experienced commissioners who have 5, 10, sometimes 20 years of experience. When the event occurred, the tragedy occurred that we're discussing today, there were not enough commissioners who had experience. That created a situation where there were inexperienced commissioners that were dealing with Mr. Galez's case. In the first decision, the commissioner had very little experience, and the other one, the second commissioner, had only 14 months of experience. And that's not enough for such a complicated case. Back in 1996, cases similar to that of Mr. Galez's took 5 commissioners to make a decision, but over the years this was reduced to 4, then 3, and now there are just 2 commissioners that make decisions. And Mr. Lafreniere, you have 1 minute remaining. Please continue. Okay. The work can be done by 2 commissioners, providing they have the necessary experience. I don't want to say that the decisions made in the Galez case were good decisions. They were decisions that did, in fact, comply with the law and the board's rules. But I do think that a different decision could have been made. And I think that the commissioners didn't necessarily have all of the experience they needed to look at all of the different possibilities that could have occurred. They had thought about repealing the parole, but when they looked at the progress that Mr. Galez had achieved, they decided otherwise. So I think that Mr. Lafreniere, unfortunately, your time has lapsed.
To turn to the rounds of questions, the 6-minute round is Madame Stubbs for 6 minutes, Mr. Lightbound 6 minutes, Madame Michaud 6 minutes, and Mr. Harris 6 minutes. Madame Stubbs.
Thanks, Mr. Chair, and thank you to both of the witnesses for being here today. Mr. Lafreniere, I guess I would just invite you to continue to expand on the point you were making about the importance of both experienced parole board members making decisions. And in this case, if you do want to comment about the impacts, which I think you were getting to expand on, whether or not you think the people making those decisions knew all the options available to them at the time?
Voici.
In deciding by not going ahead with repeal, they could have extended his parole, but not for 6 months. They could have extended for 1 or 2 months and then had a new hearing by asking for a new parole plan, asking for a new psychological evaluation that was up to date, because the one that the commissioners had went back to 2017, and they're only valid for 2 years. So they could have asked for a new evaluation, and in the meantime, well, the offender could have had a day parole, but not all of the freedoms that he had. They could have had a new hearing, and what I noted was when the first decision was made, they should have imposed special conditions on Mr. Galez, and he should have been followed up. So I think that a new risk evaluation should have been done, and Mr. Gales was given the authority to go to massage parlors. So I think that the commissioners could have imposed special conditions prohibiting Mr. Gales from going to massage parlors. I think this point was discussed during the hearings, but they decided that they simply wanted to give him a verbal prohibition. But when you just give a verbal prohibition for a special condition, that if the offender doesn't comply, the parole officer has no choice but to suspend the parole and inform the board. So when verbal instructions are given, there's a lot of latitude, and alternative measures could have been taken, and then there would have been no obligation to inform the board. Another advantage of having a special condition is that the offender if he's apprehended by the police will have access to the report. They'll see what the prohibitions are, and they can then advise the correctional service. By imposing special conditions, the correctional service would automatically have been informed of the condition. They would have known about Mr. Galez's case, and in their written decision, well, none of this was found in the text, and that deprived future commissioners who would then be called upon to make decisions. And by not informing future commissioners about this, because you have to understand they're on a rotating basis and they have a very heavy caseload, future officers were not given this information. I'd also say that I noted that it's important. There's an important gap between the decision, the verbal text, and the written text. And that had a terrible result. Commissioners with experience would have not acted in the same way. They would have imposed a special condition prohibiting Mr. Galez from going to massage parlors. And the commissioners would have probably asked for a new psychological evaluation of Mr. Galez because the one that was on file was not up to date. Does that answer your question?
Extremely insightful and indeed answers a number of questions. Thank you very much. Thanks, Chair.
Thank you. Okay. Mr. Lightbound, 6 minutes, please.
Thank you, Mr. Chair. This is a subject, well, what happened in Sainte-Foy, Quebec, was horrible, and I think it's important that we draw some good lessons from this. But repeat offenses are rare, and so the system is, even in this case, there was a failure, but it's a system that usually works. And I'd like to hear, Mr. Millet, according to your experience, what are the best practices that have the best impact to reintegrate a repeat offender?
Thank you, Mr. Lightbound. Well, I think preparation in the institution is one of the most important parts of reintegration. And I just want to say one thing as well, in case it doesn't get picked up somewhere else. I think in this particular case, and I think in any case where there is intimate partner violence, I think that is something that has to be looked at even closer than other forms of murder. As I mentioned in my statement, I've worked with people who have committed murder and people who are doing life sentences. And I think for a lot of the people, and the Seven Steps Society tends to work with recidivists, people who have been in and out of the system in the past and haven't responded well to other treatment or forms of reintegration, that the most important part is trying to get that individual to really face what the truth is about. That's our first step, in fact, facing the truth about ourselves and the world around us. We decided we needed to change. And I think realistically that in any case, preparation during the person's sentence, because if we're talking about corrections and rehabilitation and reintegration, that is probably the foundation before the person ever leaves the institution. And quite frankly, I have to agree with a lot of what Mr. Lafreniere said in his assessment of the situation. Not all of it necessarily, but certainly the just to answer your question as far as preparing people in terms of developing positive and healthy relationships with individuals who come, especially the community members who are able to come into the institution, because don't forget, people that are in an institution, especially if they're serving a life sentence, do become institutionalized, and their reference points are within the institution, and it doesn't matter what kind of programming they're getting. If they have no contact with the outside world, it doesn't mean that their initial problems were fixed just because they spent 10, 15, even 20 years in some cases in an institution. So the real preparation, though, comes as the person is cascaded from maximum, which most life sentences start as, and then down to minimum security. The last period, especially in minimum security, and exposure to the community and exposure to people who come in as volunteers and help that individual to be able to start to develop, especially if the person's had issues in the past with interpersonal relationships. That is a primary issue. And then, of course, if you have addiction issues, the person has to deal with that. And so I think that, really the sort of the process, if you will, has to start well before the person is ever released. In Mr. Gillespie's case, I have no idea if he was getting escorted passes or unescorted passes, or if he had come out of a minimum security institution. I didn't see that necessarily in the Board of Inquiry report. So, that part I'm not sure, I can't really speak to in this case, but certainly once, and especially in the case of someone with that sort of a violent incident in their background, is released into the community, they've already spent, I think in his case was 13 years. And I noticed, for example, he was given liberty from the halfway house within 1 day to be out in the community unsupervised. And to me, I think there's some safeguards that can be built in there, and a more gradual release, because and I can speak from my own experience, having been in an institution and thinking that the minute I walked out the door, my problems were solved. That's a pretty common misconception that a lot of offenders have, because they're not, because life suddenly hits you squarely in the face, and a lot of the issues that you might have dealt with beforehand are still there. So that's, I guess, what I'm saying to try to answer your question. I'm not sure I'll give you the total specific answer you're looking for, but certainly I think preparation before release is really important, and not just the CSC programs that are delivered in the institution. I think exposure to community influences is really the key factor, and especially if. Sorry,
Mr. Lightbone, 30 seconds.
Je pense que j'aurai pas le temps pour...
I don't think I have time for an additional question. Thank you very much, Mr. Mayette. I think the services that you are providing should be given priority. But when you look at we can see that it's not the National Parole Board decision where the problem lies. It was really the people that were on the ground, the officers. That's where the shortcoming lies. So, what you said made absolute sense, and it was good. Thank you.
Thank you, Mr. Lightbound. Madame Michaud, 6 minutes.
Madame Michaud, 6 minutes. Thank you. And thank you, gentlemen, for your testimony today. It's very much appreciated. Mr. Lafreniere, at the beginning of your testimony, you said that you weren't here to point the finger at anyone, but to improve it, and that's what we want to do. Mr. Mayette said that these types of cases were rare, but this time this one case was one too many. So we don't want this to happen again. You did identify the high caseload of the commissioners, that people weren't able to identify all of the options. Could you talk about this in greater detail? Perhaps that will have some of an impact. In fact, it's difficult to say whether or not this will have a direct impact or not. If the offender the fact remains that an experienced commissioner would have made a different decision. The decision that was made was not right. It complied with all the policies and the regulations, but the acquired experience helps you. You just don't look at the recommendation by the correctional service. You look at all of the other decisions that have been made. And if, in the light of after reading the decision and the facts, I think that there were certain things that would have pointed to a different decision that should have been made. Mr. Gallès was given permission to go to massage parlors. This didn't figure anywhere in the written decision. The fact that the psychological follow-up had not been done. So in the initial decision, there was talk of special conditions that that this man had a problem managing his emotions and that these had not been solved. I would have thought twice before releasing him if these conditions had not changed. I would have renewed it for maybe 1 or 2 months and asked for a psychological report. I would have looked for a new correctional service plan in the light of the evaluation that had been made, enabling Mr. Genès to go and visit massage parlors. And I would have asked for a new plan, and I would have reviewed it in 1 or 2 months' time and looked at the shortcomings. That's how I would have dealt with it. I'm not saying the decision was not the right one, but it could have been different. Thank you. You talked about the risk evaluation. If Mr. Genès had access to these privileges, it's because it was considered that he didn't present a danger to the community, but this was clearly the case. And with what factors were used to base this decision, that is that this person can be released and does not constitute a risk to the community. The parole board had information that had been processed by the correctional service. the preparation of case reports done by correctional service is done by experts. There's a correctional service plan that's established at the beginning of the sentence. There are obligations on the part of correctional service to meet certain obligations. The offender has to participate in programs. There are psychological assessments that are made. There are all kinds of factors that have to be taken into account. And when you make a decision, when you go on a cascading basis when you evaluate the risk. That's what was done with Mr. Ganes's class. He was given permission to have an honest to go out for day passes, but without an escort. But he should have had special conditions that would have enabled us to better manage his case. And we should have had a psychological follow-up. He was being followed because he had trouble controlling his emotions. He was seeing us if, in this case, the follow-up was not done properly. And this was a big factor. Unfortunately, the time is up.
Before I turn to Mr. Harris for the next 6 minutes, Mr. Lafreniere, I've just got a note saying that you can turn your camera back on again. So if you wish to do so, and I think the rest of the committee does wish you to do so, if you could do that, and with that, I'll turn to Mr. Harris for 6 minutes, please.
Thank you, Chair. And Mr. Lafreniere, good to see your face again. Thank you for appearing, at both of you, Mr. Mayette, as well.
Oui, je l'ai remis.
I'm sorry, are you able to hear?
Yeah.
Is there difficulty hearing?
Non, j'entends bien.
Yeah.
Okay.
No, I can hear.
Is there a problem, Chair? I don't understand.
I don't think so. Mr. Lafreniere, can you see and hear
Moi, je vous
Mr.
entends
Harris?
bien, je vous vois. Oui?
I can hear and see you.
That technical difficulty.
He's just exchanging pleasantries, Jack.
I
Okay.
was about to ask a question. Thank you for being here. Mr. Lafreniere, you said that there was, just if you could clarify this problem for me first, you said that there was a time when there would have been 5 commissioners making a decision, not 2. Do you mean a decision of this type with respect to the continuation of day parole? Is a question as, I won't say as simple as that, but it's not the same question as granting or not granting parole in the first place. But was that the case, that there was a time when it would require 5 commissioners to continue a day parole for an additional period?
Ce que j'ai mentionné.
What I was saying is that when I first joined the commissioner in 86 for lifetime sentences, it was reviewed by a panel with 5 commissioners. 3 commissioners were regular commissioners who worked for the board, and we would add 2 commissioners that we called community commissioners. They would sit as citizen members solely for cases of life sentences. Then the number was brought down to 4 and then down to 3 with 1 member from the community. And then we were reduced to 3 commissioners from the board, and then we were 2.
That for all decisions made in relation to any person who has a life sentence, because we understand they're still serving while they're in the community, every decision related to a life sentence, or only those about initial parole? And just clarify that point for me, please.
Toute décision.
All decisions in a
Sir, and perhaps I can turn to Mr. Mayette for a question. because I'm very interested in your 7-step program. It seems to me that it may well be modeled somewhat on the 12-step program for Alcoholics Anonymous. And the two questions arise. One is that the type, that seems to be the type of program that requires a high degree of motivation on the part of the participant to be committed to a particular course of action on their own, as opposed to being imposed upon them and say, you are directed to go to this. And secondly, is that a program that is that considered part of a corrections, part of programming, if you know what I mean? Would that be accepted as a legitimate part of a person's rehabilitation within an institution?
Yeah, first of all, it is voluntary. In fact, the groups are self-selecting for a person to become a member. Unlike AA within a 7-step group, they actually have to be accepted and voted in unanimously by the members in the group, because it's essentially based on trust and a commitment. And so what happens is if someone is interested, yes, they first of all have to be motivated to change. And secondly, they can't be mandated to join the group. And thirdly, the process of actually joining the group is they have to prove to the group that they in fact are motivated to change. To answer your second question, it's not seen as part of correctional programming because it is a voluntary participation. However, just in practice, what we see is a broad acceptance by the program in the institutions where we have operated, because of the results of the people who participate in the programs, in that they then commit to their correctional plans, because we don't see the group as a panacea. It is really just an opportunity for someone to start their true process of change. And then we will even, in a lot of cases, do what we call mock parole board hearings, because in fact, when the people are preparing for parole, if they can't convince the members of the group who have been through the process themselves and understand all of the the BS, I'll use that word advisedly, that people can come up with about why they did something. If they can't convince the group they're sincere, then how are they going to ever, convince the parole board that in fact they do understand, what caused them to do what they did in the first place? So yes, so I think it's a complementary. It's not a program because it's a group involvement, but in a sense, in a lot of institutions, and if you were to poll institutions where the groups operate, I think you would find a very broad acceptance of the validity of what the groups do.
Is there an assessment in the sense of would for example the parole board consider that a person had, or if there's such a thing as successfully completed the 7-step program?
Yes, I think you'd have to pose that question to current parole board members, but in the past, yes, we have written letters of support. We've had feedback from parole board members, and in my experience, as I mentioned, I've been involved in the criminal justice system, well, on the outside since 1973. Started my field training in 1969. But, and that's sort of a tongue-in-cheek comment, of course, but, and have had a lot of follow-up with parole board members over the years and feedback in terms of what they think of the group process. So yes, I think we've seen reference to it for people that do understand it. And
thank you. Unfortunately, that is Mr. Harris's time.
Oh, sorry.
That's all right. I am unfortunately tasked with running a clock here. Colleagues, we have 25 minutes of questions in the next round, and we have 15 minutes left. So my proposal is that we go 3 minutes, 3 minutes to 1.5, 1.5, and then 3 and 3. Hopefully that'll be acceptable. Mr. Motts, 3 minutes, please.
Thank you, Chair. First of all, thank you to both witnesses for your testimony today. You have both provided an experienced perspective, specifically Mr. Lafreniere on the mistakes made by the parole board in this case, a perspective that's shared by many Canadians with regards to this tragedy, and Mr. Mayette, for you, your perspective, among other issues, on the special care that has to be taken with offenders who have a history of domestic violence, and so thank you both for that. Mr. Lafreniere, my question to you first is, As you know, the parole board has the authority to withhold parole for statutory for individuals who are a threat to the public. You have indicated in your opening statements that the the members in this particular hearing or hearings, this case could have asked for a new hearing or new evaluation. They could have even asked for a new hearing. Do you believe that these parole members who adjudicated this case actually assessed the threat to the community accurately?
You're on mute, Mr. Lafreniere. Thank you.
I think that the evaluation that was done based on the criteria of the legislation and policies and regulations was correct, but the case could have been managed differently without there being an error. The interpreter apologizes, but once again, the sound is really bad.
Sorry, Mr. Lafreniere, I'm just getting communication from the interpreter that the sound is not working.
So, Chair, if I may propose that he shut his camera off again, and then I'll go on to the next question, please.
Yeah. Okay. Sounds reasonable. Okay. Go again, Mr. Lafreniere. Did you want to complete the thought, or did you want Mr. Motz to ask you the next question?
I've got the answer required. Thank you, Chair.
Okay. So, Mr. Motz, why don't you proceed, and I'll start the clock.
This question is to both Mr. Lafreniere and to Mr. Mayette. We've seen the fallout of this from accountability perspective, and it was surprising to many people across the country that the only accountability really that took place here was frontline individuals would be accountable. The parole board themselves would, there'd be no accountability there. And that surprised a lot of them. So what's your thoughts on that? Plus, is there any thoughts on the fact that, the correctional investigator, has a place or has a role to play and to be independent investigator rather than the parole board and corrections investigating themselves in this case? I wouldn't mind your perspective on both of those.
Very quickly, please.
Mr. Mayette, I'll start with you first, please.
Sorry, I got lost in the process. Could you just quickly repeat your question?
Unfortunately, we are running out of time here. It's
okay,
3
sorry.
minutes. Yeah, I apologize to everyone, including Mr. Motz. We're not going to be able to get an answer to his question. Possibly somebody could pick it up later on. Madame Lambropoulos.
Thank
3
you.
minutes, please.
Thank you, Mr. Chair. And I'd like to thank both of our witnesses for being with us today. I guess my questions are going to go to Mr. Mayette. Mr. Mayette, you spoke a lot about how good a program 7 Steps could be and could act as a support group. You've been involved for 38 years, and obviously you've seen many positive cases. I noticed that the services offered are only offered in certain provinces and not in all of them. There are not chapters in every province, including in my own province of Quebec. And I was wondering if there's anything particularly blocking it, or if it's just because members haven't necessarily found out and started a chapter in these areas.
Well, primarily, I think because we're a volunteer-based organization, we do get some support funding from public safety for volunteer development. And so to answer your question, though, in fact, we are in the process of starting a chapter in Montreal. And so that will be changing fairly soon. But over the years, we have never been a largely funded organization like John Howard or E-Fry or others. And we, being a somewhat of a self-help organization, we're dependent on volunteers in the community. And so where we have success and find local volunteers, and particularly ex-offenders who will get involved, then we will establish chapters in those areas. And in fact, due to some extra initiative on our part. In the last couple of years, we've expanded into Southern Ontario, into Saskatchewan. We were just about to start in Winnipeg here prior to COVID, and through COVID, in fact, we have also now picked up some momentum in the Montreal area and in New Brunswick. So yes, we are limited in certain ways, but where we are able to establish a base, then we will provide services. But we are largely a volunteer organization.
And I noticed that I know that you're a volunteer organization, but what are the methods that you use for outreach, and how do people find out once they've been released or once they're on parole that your organization exists and can help them if they actually do want to change?
Well, we try to distribute information in institutions through other community organizations. And for example, I mentioned earlier that I sit on the board of the National Associations Active in Criminal Justice, which includes all of the criminal justice community organizations, like I mentioned, John Howard E. Fry, Salvation Army, St. Leonard's. And so through their organizations as well, we will try to disseminate information. And of course, we have a website, which I'm guessing you looked at just from your comments. So, and not that all inmates have access to websites, because in the institutions, they don't. And
Okay,
so
unfortunately, we're going to have to leave it there, Madame Lambropoulos.
Thank
you.
Madame Michaud, a minute and a half.
Thank you, Mr. Chair. I have a question for Mr. Mayette. Your experience is fascinating, and the work that your organization does is very important for offenders. Recommendations were made by the committee and by the National Parole Board and the Correctional Service of Canada, but no recommendations were made by the Parole Board regarding the prevention of these types of situations. Based on your experience and based on your reading of this case, would you make any recommendations, personal recommendations, to improve the way that the system works? Or do you think that everything's going well and that we should just keep the status quo?
In about 30 seconds, please.
Well, I think, as I mentioned before, and somebody else commented on it, about when you have a case, especially a case of intimate partner violence, I think that is somewhat unique in as far as, at least in the people who have committed murder that I've been involved with. And I think there has to be a very intensive psychological assessment and follow-up in the community. And so I would say that that's why I said earlier, I agreed with some of Mr. Lafreniere's comments as well about additional oversight. And it's never too late to change a decision. You know, if somebody was released and needs to be corrected, then it has to be done.
Thank you. Madame Michaud, Mr. Harris, 1.5 minutes.
Yeah, thank you. Clearly, Mr. Gillies was a high risk to reoffend when he was left out, and the evidence is from the result of what happened. Either he was not properly assessed on the way out, or he was not properly managed. I don't think we have the answers to that question. Do you? What's your opinion, and both of you quickly? Do you believe this requires a further investigation and a further independent inquiry into how his case was managed both inside and outside the institution?
And if Mr. Lafreniere could turn off his camera, we might get a better sound. We'll go with Mr. Mayette first.
Well, additional investigation wouldn't hurt, and I'm not sure that I have a specific answer as to what that should consist of, but I know that if it's a high-risk situation, revisiting it, and after all of this information is collected and there are recommendations made, I would go back and sift through those and take a look, and I would defer to experts in psychiatric assessment of individuals like Mr. Gillies.
And very briefly, Mr. Lafreniere. I can't see him.
Est-ce que vous m'entendez?
Can you hear me now? Yes. the joint investigation that took place between the National Parole Board and the Correctional Service is necessary when there's a tragedy such as this one. The problem with this type of investigation is public perception. It gives the public the impression that's an internal investigation and that people are investigating themselves. So I think it would be good to have an investigation done by an outside party to reassure the public that the investigation is done in an independent fashion. But I'm not criticizing the work. It's a question of perception.
Mr. Van Popta, 3 minutes, please.
Good, thank you. So, Mr. Mayette, thank you, and Mr. Laferniere, thank you for being here, and I've listened with great interest to your testimony. Mr. Mayette, I was reading on your on the website for 7 Steps that there is no program which has been effective to really reach out and influence, I suppose, hardcore convicts. Would your organization be an exception to that rule, or is that just a problem that we generally face?
I would say we're not the only exception to the rule, but we certainly are one way of reaching people who have not responded to sort of the standard rehabilitation programs that are there. And part of that is our self-help base, and that people who feel they can't connect with other organizations or programs just because they identify that as part of the system will be more amenable to participating in the 7-Step type of program. Of course, we're not the only answer, but in a lot of cases, we certainly have had an impact on people coming from that background, yes, for recidivists in particular.
Good. So thank you. Do you think, do you feel confident that if your program had been available in Quebec for the subject of our investigation today, would that have made a difference for him?
Well, if he had passed the test and been able to join the group, I guess, first of all, it would have been an assessment by the group if he was sincere and actually had faced his problems. We certainly have had other people with psychological issues and people who the group has actually encouraged to take psychological counseling, psychiatric counseling because of trauma. A lot of people who come through the system have experienced severe trauma earlier in their life, and we're not a psychotherapy group. We strictly try to deal with people, facing and dealing with their issues. But in some cases, and I can't say specifically in his case, but something like that may have been effective because it does get the person to actually examine what their real issues are and potentially deal with them, as opposed to acting out on their impulses and anger, because in a lot of cases, and in this case, of course, that's exactly what happened.
Thank you, Mr. Van Popta. Unfortunately, we're running here. I apologize. Mr. Iacono, final 3 minutes, please.
Merci, Monsieur le Président.
Thank you, Mr. Chair. Mr. Mayette, considering your personal experience and your experience with a lot of ex-offenders, what are the long-term effects of a pardon? What is the positive impact of that?
Well, I think the biggest impact is restoring some self-esteem. Some of you may have seen that I appeared in front of a standing committee back in 2010 before the Pardons Act was dismantled, which was a big disappointment to me. So I won't take that platform here today because we're here about something else. But in my case, I would say that it restored a lot of my personal feelings of self-worth and gave me confidence to be able to, go out in the community, which I did. I mean, I worked in the system for a number of years, and I left in 1982 from the 7-Step organization as a staff person, stayed as a volunteer, and I went to work in the oil and gas business and had a successful career for many years, and was able to give back. And I think that that's probably one of the biggest benefits for me personally, and I would say to a lot of other people. Plus, it opens doors for people who don't have to say on an application form that I have a criminal record. Because if you, under the Pardons Act now, and as a record suspension, that has changed somewhat, and hopefully that battle isn't over yet. But in any event, the individual who can regain some of that self-esteem gives them that extra boost to continue on with their direction in life.
Merci. Dans le cas de...
Thank you. In the case of the Marlene Levesque tragedy, Mr. Gilles was a violent offender with an organization such as 7 Steps Canada. Are there specific measures for this type of profile? Has something like this been looked at?
Are you asking me that question?
Yes.
Within the 7-Step organization, or generally speaking? Okay, well, particularly within our organization, because we've dealt with a lot of people with violent pasts that have killed other people. And in a lot of cases, though, the circumstances were different because they weren't intimate partner violence. I can't say that we've had one life, a person serving life for murder who has participated in our program who has been in that same situation. And so most of the people we've had have been drug-related, gang-related types of violence, bar fights, etc. And so I would say that in the case of Mr. Gilles, it was, more of a psychiatric issue, I think, and something that maybe wasn't addressed. And again, I can't speak to it entirely, but I don't know specifically within the the CSC system, how they address it. I know they have psychological assessments and try to deal with it that way. So accountability is the key issue for any individual that's in that situation. And if they were to be involved in our group, that's what we primarily focus on.
Merci,
Okay, we're going to have to leave it there. Thank you, Mr. Iacono. That brings this session to a close. I want to, on behalf of the committee, thank both Mr. Mayette and Mr. Lafreniere for not only their testimony before the committee, but also their many, many long years of service to the larger community. It's admirable what you've done over the years. So thank you for that. With that, we are going to suspend, and the clerk will arrange to let our other witnesses in from the green room. Our new witnesses. I'm assuming you've been appropriately briefed, and so I'm going to turn to Ms. Campbell for the first 7 minutes, if you would, please. I apologize in advance for probably cutting you off at some time during the next hour, but this is just the way it works these days. So try to look up at the chair from time to time, and if I'm waving my hands frantically, it probably means I would like you to stop. So with that, could I have Ms. Campbell for your opening statement of 7 minutes, please?
Thank you, Mr. Chair. Just very briefly, for those of you who don't know me, I'm a lawyer by background. I was at Solgen Solicitor General Canada and then Public Safety Canada from 1984 till 2013. So you can do the math under 4 different prime ministers and 3 different governments. Very quickly, I want to make 2 points, and the first one focuses on the roles of CSC and the Parole Board of Canada, because I'm still hearing a lot of crosstalk and a lot of confusion about what each one is responsible for. Parole Board of Canada is responsible for decision-making, period. Once they have made a decision about a case, it is handed over to CSC to supervise, to manage, and to come back to the parole board if something is starting to go off the rails or something needs to be changed. The board has no role to play while the person is in the community under that supervision. The board relies on the information that CSC brings to them. And that's fundamental to understanding this case. The second point I want to make relates to the facts, because I'm hearing, if I may be so bold, an absence of certain facts. When we look at the March decision, he was already 2 years past day parole eligibility. It wasn't a rush case. He had over 300 escorted temporary absences into the community, 300. He had 11 unescorted temporary absences. He had completed programs, treatment, AA, NA, he had family support, halfway house support, parole officer support. That decision, if you can point out where the mistakes were made, the page and the paragraph number, I would really be grateful, because that decision appears completely solid. It's one of the best decisions I've ever read, and I've read quite a few. The September decision, there were 9 days left in the day parole, 9 days. They were there to consider a new day parole. The board was essentially, I would say, blindsided by what they heard. They were not aware about the contact with the sex workers. They immediately suspended the hearing. The 2 board members talked between themselves, and they talked about revocation. This was on the table, that the hearing, that they considered revoking the release. They came back into the hearing with the PO and Mr. Gillespie and made it abundantly clear that revocation was on the table. They were so concerned about this. The parole officer opposed that, said that they could manage the case. Mr. Gillespie obviously said he would behave himself, that he'd follow the conditions that were set by the board. The board, on a balance, decided it was worth continuing the day parole. 2 years later and 500 miles away, I guess, sure, you might have made a different decision. But again, the law and the facts really supported the decision that they made that day, and they did not ignore the seriousness of it. Everything really went off the rails after that, when the board had no involvement in the case whatsoever. September 24th, Mr. Glass met with the PO to talk about the decision. And unfortunately, October 9th, he was assigned a new parole officer. All right, barely 3 weeks after this hearing, he got a new parole officer. That parole officer acknowledged that they did not read the entire file. They did not read all the documents. They did not talk to Mr. Glass about the original offense. Okay, and in terms of doing collateral checks as to what Mr. Glass was up to in the community, if he says he's working somewhere, normally you go to the place of employment to make sure he's met with someone, you talk to that person. No, this PO, I'm sorry to say, and I'm quoting here, took it for granted, unquote, that Mr. Glass was complying with the board decision. Took it for granted that he was complying. And tragically, as we now know, he was not complying at all. As a result, the parole officer failed to recognize that the case was going off the rails and therefore failed to contact the parole board. Normally, what we would do in that situation is set up a parole hearing and say, look, either we need to change the conditions. He had 6 special conditions, or parole board, you need to look at revoking this hearing. It's not salvageable. That was not done. So I think when we talk about how things could have been different or who could have done something different or better, those 2 decisions, in my mind, are not the problem here. It is the supervision that Mr. Glass was under. Now, we can also talk a little bit about statistics if you wish at some point. Stats are irrelevant to a grieving family. Forget it. They are irrelevant to a grieving family. But stats are very important to you because you're the legislators. And if you want a different system, a system where the supervision and the parole board decision-making are closer, that is absolutely your entitlement to do. I was one of the creators of the Corrections and Conditional Release Act. There are other models. And, one time supervision was under the Parole Board of Canada. So there's no particular magic to the system we have now. You could have a system of release where there is no parole board involved, in fact. So those are all on the table. But in terms of what would address or what would have changed what happened here, there is one person to blame here. If we're looking for blame, there is one person to blame, and that is Mr. Glass. And let's be very clear about that. And there's very evident that there were flaws in the community supervision that had they been rectified, tragedy might have been avoided. But as I say, if you can show me in the parole board decisions where an error was made there, I'd really love to have that discussion. I'm going to stop right there, Mr. Chair.
Yes, thank you. Excellent. Within 10 seconds. Thank you very much, Ms. Campbell. Madame Roy, 7 minutes.
Ms. Roy, you have 7 minutes. Thank you, members of the committee. I'd like to thank you for allowing me to share my opinion. I hope that I'm going to talk about the victims and the survivors. I have a legal criminology degree. I've worked in various organizations, but for the past 8 years, I accompanied families and family members of victims. We have more than 800 members in Quebec alone. I also worked for the Association of Murdered and Disappeared People. I've met with families who are very brave, resilient, but many families are dealing with grief, tragedy, catastrophe, and they're hardly prepared to to deal with this whole situation. The process is often the trial often happens many years after the situation, and they have to deal with the costs as well. Then there's the incarceration of the person, or the feeling of justice that needs to be redefined. For these, it's difficult for people to understand the whole situation. But a few years ago, we did come up with our Canadian Charter for victims, but we tend to put more emphasis on the offender rather on the victims. It's very difficult for these people who have been broken by these catastrophes. With the Canadian Charter of Victims' Rights, we have to understand the scope. The right to information is important. The families are not informed about the dangers. In the case of Mary Lynn, where we have to remember the previous victims as well, they were not. We have to be able to consult with these families, understand the impact of these crimes. How do you protect people how do you protect Mr. Galez's victims? What did we do to protect Mary Lynn? The constitutional was a failure in this. Mary Lynn Levesque had the right to be protected. She had the right to life. She had the right to be protected. We all followed the newspaper articles, but what I have discovered is that the Correctional Service of Canada and National Parole Board on January, Mary Lynn was killed in Quebec. The offender, Galez, pleaded guilty to first-degree murder and convicted on February 3rd. The National Parole Board and Correctional Service of Canada established a national investigation, and the first conclusion came out in 2009 and responded to all of the requirements for training and the level of knowledge necessary. Let me tell you that I don't agree with the report. The training of an crime impact or shelters for women who have dealt with violence was not taken into consideration by the Parole Board. The families are therefore resigned, and they have the only thing they can do is read a statement that takes all of their energy and puts them back into this bad place. The commissioners don't seem to apply the Conditional Release Act provisions, but they're supposed to provide all of the relevant information when they make a good decision. In my opinion, I think the commissioners did not have the knowledge or the training required in order to look at the precursor signs of violence, the training with respect to violence. The expertise could have been used in making this decision and in training these commissioners. So it's very easy to look away from where the responsibility lies by saying that this only happens very rarely. But in my opinion, this is one life lost too many. I think we should really focus on the protection of society, rather than trying to simply focus on the offenders of these violent crimes. That's my opinion. I think when you read the Parole Board report, it's insulting for the family members of the victim and for society. And society needs to be protected when offenders are released. And despite the fact, I think that there's a form of mea culpa going on here. We really need to look at the protection of potential victims. We can't issue recommendations by simply saying that we need to improve supervision. it's utopic to think that you can really supervise all of these people. We realize with the number of women that are killed in Quebec that this is the case. How do we protect women? Not everybody is a repeat offender, but we do need to improve funding for transition houses. We have to do the work upstream. The problem has to be looked at before the release. We have to ensure that protection measures are in place. I would therefore recommend that there be some immediate changes. One, that decisions be made exclusively while bearing in mind the protection of the victims. And if there's any doubt, if there's any harm, this must be considered. We have to ensure that the commissioners have better training. We have to look at the impacts. We have to, as the Quebec Bar Association does, and I'm a member there, or any other type of professional order, we have to require a minimum number of ongoing training hours. We have to, Ms. Roy, your 7 minutes is up. I just have 10 seconds remaining. Perfect. That in where we could require that there be a psychiatrist or a psychologist that sits on the board and not just simply look at reports, but have someone there, part of the decision-making process. And I will continue if there are any questions for me.
There will be questions, I can assure you. And the first question will come from Mr. Palus. Bienvenue au comité.
Welcome to the committee, Mr. Palus. You have 6 minutes. Thank you, Mr. Chair. First of all, I'd like to say that the family of Marine Levesque has suffered a great deal, and I share their pain. And that's why we went ahead with a motion which led to this study. We have to look at the problems that exist in the National Parole Board and the Correctional Services Canada that led to this. This was an atrocious murder, and this Mr. Gillis was able to have the ability to go out and visit these centers. Who could? It is absolutely necessary that we shed all light on the circumstances of this assassination to ensure that this type of murder never occurs again. The first observation is that nobody from the National Parole Board or from the Correctional Services Board is said that they're responsible for this atrocity. Before the commissioner gave the green light to the parole release, to the parole conditions, and which led to the tragedy. We need to look at the training of the National Parole Board. The commissioner is dealing with a lack of commissioners. Commissioners based their decision on a psychological assessment that was outdated. We have to ensure that profiles are updated on an ongoing basis. Another barrier for public safety was disregarded. The transition house could have looked at the comings and goings of this criminal, and we need a better social net for this. Based on the testimony that we've heard, the National Parole Board is not responsible. The Correctional Services are not responsible. The Government of Canada is not responsible. So we may very well have to deal with these types of incidents again. Nobody took Marilyn's case seriously. There's no excuse. If it was your child that had this happen to them, what would you do? So incompetence cannot be tolerated. We need to have a report with follow-up, a report that should say the things as they are and make recommendations. Thank you very much. I would also encourage Ms. Roy to continue because perhaps you could go into further great detail about your recommendations. What I'm suggesting is the administrative tribunals. have to have a psychologist or a psychiatrist sitting on them to look at any shortcomings. We need to have a a mandatory psychological follow-up. I would like us to introduce a public registry on repeat offenders that are at high risk in order to protect our victims. We have to protect all potential victims, and you were asking that communications with the family of Mr. Bolduc, with Ms. Levick, that the trial be transparent, because if not, we were simply asking these families to remain silent. Yes, harm has been done. Harm has got to be compensated. Agreements can be reached, but I think that we need greater transparency and accountability. That's what I would recommend. Thank you very much, Ms. Roy. This is the last day of the study that was as a result of the motion that I tabled at the House of Commons. Everyone agreed with this. I'm looking forward to the committee report that will be issued. And then there's another report that was done by an internal investigator of the government. And this report was not made public. Can you tell us what you think of that? I think that, unfortunately, the victims are always kept in the dark. Their rights are not recognized constitutionally, and often the investigations and all the research, all of the commissions that can be established, unfortunately, nothing has been made public. There's no information for the organizations that accompany the victims. Yes, we're talking about Mr. Gales and others, but we mustn't forget that there are many different victims, not just the person who's assassinated. You have all of these family members who have been hit by this, and unfortunately, these people are condemned to never have their loved ones with them. You talked about commissioners with not enough experience. In 2017, the commissioners were let go, new ones were hired, and this was a radical change. What impact did this have? Yes, it had quite an impact, because the transfer of information, and you have to have a minimum level of education in order to recognize the precursor signs. You need experienced people, as we saw from Mr. Lafreniere. You need people with a great deal of experience with offenders, and I think that these are files that should. You need to have someone looking at these files who have a level of education and experience. Thank you.
Minutes, s'il vous plaît.
Thank you, Chair, and thank you to both our witnesses for being here. My question is for Ms. Campbell. Ms. Campbell, thank you for being here and for your testimony, and importantly, all the work that you've done and on your advocacy. I really want to first thank you for stating the fundamental fact and the difference between the Parole Board of Canada, the CSC, because I find there is still so much confusion about their roles and the work that they do, including, and the members in this committee. Can you, maybe I'll just allow you to perhaps clarify that for this committee.
Yeah, just a couple of comments on parole board appointments in particular, because as I say, I've been there through the Mulroney government, Chrétien, Martin, and Harper. I've seen a lot of appointments. That was part of my job. You have to understand, first off, the model that you have is you are appointed for a fixed term, usually 3 years or 5 years. That's it. No one should have any expectation they're going to be renewed. That's the model, is it's a short-term or fixed-term appointment. Some people are renewed, some are not. If you want to have a so-called professional board where people are given a job, a permanent job, that's a different model. Your parliament If that's the model you think would be better, you write the laws. But the one we have right now is, it is a fixed term appointment. The board has other things to take into account, such as having a diverse board. They are required by law to have a board that reflects the community. That means different ethnic backgrounds, different race, different gender, different life experience. They've got to manage all those things. And if you end up with a board and it's done regionally, you're appointed to a region, if for some reason, just happenstance, you end up with a board where everyone looks the same, speaks the same language, no other languages, you've got to balance that. And that's why sometimes, board members, their term ends, they've done great service, thank you very much. Now we need to fill in some other gaps so that we have a board that looks like the community. And that's an important point for the community to understand.
Thank you. Thank you for that. Ms. Campbell, in April 2015, you said that, we are witnessing the demise of the parole system. Since then, have you seen any improvement within the parole system under the current government? And what else do you think needs to be done?
Oh gosh. I wrote a list in the fall of 2015 about what needed to be done. I still have that list. I think that some things have improved. There's been comments made that the number of people out on parole has increased and that that's a bad thing. No, I think you have to look at that number. Yes, it has increased, the number of people on parole, but that was only in relation to the dramatic decline prior to 2015. The parole numbers went way down. And so you don't have actually an unusual increase since 2015. It's just a normal increase back to numbers. The system by and large works well, but I think the Board of Inquiry made some important recommendations. I was shocked to see that CSC parole officers were not trained in domestic violence. As George Mayette has said, I think that's a particular kind of violence that they need training in, and board members as well. I think there are great efficiencies that we could be applying in parole supervision. Not everyone is a psychopathic monster. And far too many resources are devoted to those who don't really need them. So, there are just streamlining amendments that could be made that have not been made. There are things that have been done that I think have really done a disservice to the process. I can share my list with you sometime.
Please, yes, I think that would be great if you can share that list with the committee.
Yeah, I think, there's always, of course, there's a terrible case happens, and this is such a tragic case. The natural instinct is, well, we need to change the system because of one case. And that's really the worst thing you can do. You really have to pinpoint, if you can, what happened. And these cases, as tragic as they are also very rare, which makes it very, very difficult to predict. And to know in advance, the risk assessment said 4 out of 5 people with his profile would not reoffend. Well, tragically means 1 likely will offend. And how do we figure out who?
Thank you. Thank you. I know I'm running out of time, but if I may, and if you don't get to finish your answer, maybe you can include that in your testimony. What are your thoughts on the current pardon system and the impact it's having on allowing ex-offenders to successfully reintegrate, understanding that this was in the minister's mandate to reduce systemic barriers to record suspensions?
A little less than 30 seconds, please.
Yep, I think as Mr. Mayette has said, tragic reforms were made to the Criminal Records Act. They have not been undone. So there are 2 major political parties that apparently think that it's okay, and I'm strongly of the view that it's not helpful to reformation at all.
Thank you, Madame Gara. Madame Michaud, 6 minutes.
Yes, 6 minutes. Thank you, Mr. Chair, and thank you to the witnesses for their testimony. Mrs. Campbell, you talked about the different roles of the different institutions. You talked about the facts, the decisions that were made. And you said that a good decisions that it was a good decision made, and that most are. There was a shortcoming with a parole officer who had been assigned to the case just shortly after the offender's release. Is he the one that he's the one who gave the permission for Gillespie to go and visit massage parlors, and that's where he got to meet Miss Levesque, and this led to her murder? I'd like to hear your opinion on the decision that was made. Is this type of decision a common one? Was it appropriate? And
no, that new parole officer was not the first one that allowed those visits to happen. And again, you have to go back to the 6 special conditions that were placed by the board in the spring of that year. There is a fundamental difference between conditions imposed by the parole board and instructions that are given by the parole officer. You've got conditions, you've got instructions. And to use a technical term, I have seen some instructions that are Lulus, that do not conform to the conditions. They go beyond it, they contradict it, they contradict the law. In a document, I think I called instructions the Wild West of corrections, because there's very little monitoring of them. Only the parolee themselves knows what the instructions are. They're intended to flesh out the conditions. You know, if a condition says, don't go to places where alcohol is served, you know, you can parse that out a lot of different ways. And so the instruction is intended to say, don't go to anywhere that's a bar, don't go to anywhere that doesn't serve any food. But in this case, the initial parole officer said it was okay to go and have the visits with sex workers. And that's really where it got off the rails in that sense. I think that I don't want to hang any parole officer out to dry, but it's very clear from the evidence to me that that's where things really fell apart. And you had very good testimony, just quickly, from 2 sex trade workers. And I thought they made some very useful points about how the current laws around sex work really cause danger to a lot of the workers. And I think I would hope that you and your colleagues on the Justice Committee would actually have a look at the current legislation. I thought that they were very useful in the comments they made.
thank you. I've noted that. In an article in 2015, they talked about the remorse of offenders and how decisions are made by the National Parole Board. In your opinion, I'd like to hear your opinion about that.
Yeah, you know, let's be clear. I mean, I've been very candid all the way along, and people are free to disagree with me. I felt that the message that was sent down to everyone in the system was quite a harsh one, and it was listened to. And there was quite an emphasis put on, are you remorseful for what you did? And remorse is not irrelevant. If you show remorse, it is, in a sense, you're acknowledging, you know you did something wrong, you know that you shouldn't have done it. And it's a starting point then for rehabilitation. But to have that as the primary factor, there are people who will never feel remorse. First of all, because they feel they did not commit the crime, and many of them are right. But also it's not in their makeup, and it doesn't necessarily mean that they can't be rehabilitated or live safely in society. And so this notion that you must really almost grovel and display constant remorse may be unrealistic, and it's not necessarily the most important factor in determining your risk of reoffending. So I did feel that for a period of time, there was far too much emphasis on that to the detriment of other more scientific factors in assessing risk.
30 seconds.
Quels seraient les autres facteurs?
And what other factors should be considered in your opinion?
Well, I think that the science of risk assessment has obviously improved greatly over the years. It's not a precise science, but you have to bear in mind, it's not just a binary in-out decision the parole board makes. It's what are the conditions that would make this release safe? Nobody is 100% or 0% one or the other, risky or not risky. It's in the crafting, I think, of the conditions and in the nature of the supervision that is equally important.
Merci, Madame Michaud.
Thank you, Ms. Michaud.
Minutes, please.
Thank you, Chair, and thank you to both of you for attending today. Ms. Campbell, first of all, I just want to say thank you for bringing up the Criminal Records Act, and to Mr. Mayette as well, as having been a beneficiary of the pardon system. I will say to you that I'm of the party that, and was personally involved in fighting against the changes to the Criminal Records Act that got rid of the pardon system and called it a record suspension, whatever that means to the general public. So that battle is not over. But thank you for that. I want to refer to you, first of all, can you tell me, and everybody listening and watching, they're called parole officers, and you referred to the parole officer being present. The parole officer does not work for the parole board. Am I right or am I wrong?
You are absolutely right.
The parole officer works for the Correctional Services of Canada and is involved in the supervision of the offender in the community.
That is correct.
Okay, thank you. I think that is a source of some of the confusion.
Mm-hmm.
I want to refer you to the same article that Ms. Michaud did, but a different point. You talked about parole being not so much for the offender, it's for you and me, saying when used properly, eligible inmates help smooth their transition back to society, which paroling inmates help smooth their transition, which reduces their likelihood to reoffend. Fair enough. The main test for paroling an inmate should be whether they are a risk to the public, Campbell said. Other factors are weighed as well, but ultimately, if a candidate poses little risk to the community, they should be let out under supervision. I believe my assessment of what you said in your opening remarks is, and in response to questions, is that, in your opinion, the decision to parole Mr. Gayes in this case was correct, that he was properly assessed, that he was therefore of little risk. Now you've defined that, I suppose, by saying a 20% risk is enough to be considered a little risk. Do you stand by that?
Well, that's not my assessment. That's what the risk assessments say, that a low-risk offender is defined as against at least one of the risk assessment tools as 4 out of 5 will not reoffend in this matter. But it's not directed towards the individual. It's saying out of people with this profile, 4 out of 5 are unlikely to reoffend. Public safety is always number one. There are perhaps different pathways to public safety. One of the advantages of getting people out serving their sentence in the community is that there's a possibility then that they can actually do something to give back to the community while they're out on parole, as opposed to sitting in a prison cell, thumbing through the TV channels. You can impose conditions that would be far more useful in terms of volunteer work or indeed in education or training. And I'm not just sort of making this up. We did a big study at one point of the inmate population because I was concerned, there are high-risk offenders, they get a lot of attention. I wondered how many low-risk offenders there are and at what stage are they being paroled? Or are we spending or wasting a lot of money keeping them inside? And that study was very revealing. It did not get a lot of attention, but it showed that about half the inmate population is actually considered low risk, and there are other alternatives. But in some cases, you have to create those alternatives.
Yeah,
you know, you
there's
can't just say, okay, you're out, you know.
I'm obviously not in favor of that. But the situation also is, of course, in prison that a recent study shows that many of the inmates are over-assessed for risk at the beginning in a biased manner. Black individuals and indigenous people are over-assessed, don't get access to programs, don't get access to parole as a result, by putting in maximum institutions. So there's a lot of problems that need to be solved. But in this case, I'm a little concerned if the public sees that a 4 out of 5 chance or a 20% chance of reoffending is considered a criterion, then that certainly means I don't think we should keep the other 4 in because one might offend. But surely a better system is needed than that type of risk. Don't you agree?
Well, I think it's important to remember that's not the only test for releasing someone. That is one factor, is the risk assessment scores. But a whole lot more goes into making that decision. Simple things like, do they have a home to go to? Do they have a supportive family? Who are their associates? Are they still hanging out with other offenders? So I don't want to leave the impression that somehow if you're in the category where 4 out of 5 won't reoffend, you're good to go and, you know, carry on. It's simply the risk assessment is one tool that is used and weighed by the board. You know, the board in this case, the inquiry team listed all the things that the parole board looked at: police reports, judges' sentencing comments, letters from the community, victim impact statements. A ton of different kinds of information went into that mix. So I don't want to leave the impression that it's risk assessment scores alone that'll get you out. That would be a mistake to go. That's almost like the United States Sentencing Commission, where they had grids, sentencing grids, and you just sort of added up. Well, if you got 2 here and 5 there and 6 here, that's 18 and you're good to go. I don't think that's a great system.
We're going to have to leave it there, Mr. Harris, unfortunately. Colleagues, again, we've got 25 minutes of questioning in the next round, and we only have about 15 minutes left. So I think I'll adopt what we did the first hour, which is 3, 3, 1.5, 1.5, 3, 3. So 3 minutes, Mr. Kirk.
Thank you very much, Mr. Chair, and let me thank both witnesses for being here. Ms. Waugh, I appreciate a lot of what you've shared, and thank you for your advocacy for victims. Could you share if you feel that if the parole board lacks sensitivity towards victims, specifically female victims of violence, and then a follow-up question, because I'm short on time. So the victims of violence, but then also by extension their families and those affected.
What I can share with you is the observation is that when I accompany a family, well, we mustn't forget that Mr. Gilles had already a first victim, and it was Chantal Deschênes. We often forget about her. And when I accompany families, well, some have been coming who have been reading statements before commissioners year after year. Often these statements were given to the offenders. And these people don't have the right to ask any questions. They're not entitled to have an opinion. And they have the impression that their attendance is not even considered. Maybe it is. It must be. But I think the commissioners don't have training about domestic violence, about the impact of crime on these families and the consequences. Mr. Gilles had a danger, had already been identified as being a dangerous individual. Why take the risk of releasing him and making another victim? Now we have a family that there are many families that are wondering why this dangerous man was released, where there was a high potential that he would commit a repeat offense.
Thank you very much for that, and I appreciate that, and hopefully I have enough time for one more question that I think
30
is very,
seconds.
very relevant. What is needed to give victims the proper voice at parole hearings so that unreformed and violent offenders are not repeating these crimes once more, like we see in this tragic case?
I think that we need to listen to these families better than we're doing now. I think we also have to let them speak, because we've seen since the pandemic that some families have made their statements by telephone. That's not right. These are people whose lives have been altered dramatically, and they're given so many minutes where they're given very little consideration. So,
sorry to interrupt, Madam Moore.
Okay.
Thank you very much.
Mr. Yakino, 3 minutes, please.
Merci, monsieur.
thank you, Mr. Chair. Ms. Campbell, the investigation committee made a recommendation with respect to the Correctional Service of Canada that the training on domestic violence be part of the initial training given to commissioners, and that they get some ongoing training as well. Do you feel that this recommendation is useful, and do you believe that it will contribute to provide better supervision of offenders that have a risk factor when it comes to women?
Yes, as I said, I was shocked to read the inquiry report's comment that parole officers did not have specific training in domestic violence. And I think the recommendation is a very solid one. And I think the recommendation should be taken up not just by CSC and the parole officers, but also by the parole board and the board appointees. I think, the education has to be initial and it has to be ongoing. Parole officers will say to you, look, I've got, a caseload that's far too high already. I don't have time in my day. I've got so many reports to fill out, etc. I think that that's, again, something for parliamentarians to take into account. Are they resourced to properly do their job? And we know that the community side of CSC is a minuscule part of the CSC budget. A minuscule, less than 5% goes to the community side. I think that is tragic. I think more training, especially on domestic violence. If I were you, frankly, I would call CSC back in a few months and say, so what have you done? What is the training? What have you implemented? What's your plan? To find out, to hold their feet to the fire on that one.
I'd just like to make a comment, Ms. Campbell and Mr. Chair. If you have any other solutions, Ms. Campbell, about how we could improve the system, it would be very much appreciated if you could send them through the clerk of the committee.
I'd be happy to do that. Yeah.
Thank you. Madame Michaud, a minute and a half.
Ms. Michaud, 1.5 minutes. Thank you, Mr. Chair. I have a question for Ms. Roy. Mr. Gilles was released. He was dangerous. In your opinion, as soon as there's a potential for any risk, as minimal as it must be, do you think that this person should be given a release? Well, as far as I'm concerned, I think that the legal system is going to have to look at the victims and look at the rights of those people and potential victims. We must not forget them either. So whether this be at the correctional services level, whether this be at the parole board, I think that these people should think about these people. We do have a victims' right charter, but unfortunately, most of the rights, be the right for compensation, well, people just don't know where they're supposed to turn to. So I think as soon as there's any doubt about the level of dangerousness of a person, we have to look at the potential victim. You talked about the way that the victims have very little say in all of this, that they can make a statement and it's going to be handed to the offender. And it must be very traumatizing for the victim that the offender is going to find out details about their lives, and that creates more fear. It's a tool, but it's a tool that might not be as useful as it initially seems to be, because the commissioners can decide to release these people at any rate.
Madame Michaud is out of time. You probably try to work that answer in some other fashion. With that, we'll turn to Mr. Harris. Minute and a half, please.
Thank you, Chair. And I reiterate the request for any other information that perhaps if you find that list from 2015, or maybe some of them are contained in an article written by yourself and Professor Dube, that might be helpful, or anything else. There is a concern that I share about this whole case is about a person offending who had a history of intimate partner violence, clearly identified as the major risk of reoffending, that in the sense of what one might be concerned about. Dr. Zinger has told our committee as well that there's far too many per capita of prisoners in the staff and correction services institutions as compared to outside as well. Is that something that ought to be addressed by government as soon as possible? Is that a high priority, or are there so many things for correctional officers to do in prisons that they need them there too? Do we need a bigger budget? And second question is, given that correction officers aren't properly trained in intimate partner violence as an issue with the offenders, is there anything equivalent within the prison system itself?
Mr. Harris is giving you 15 seconds for both of those questions.
Yes, and no will do.
I know Dr. Zinger has identified the number of staff per inmate ratio. I would beg you not to give more resources, I'm sorry, to the institutional side. Give them to the community side where they are desperately needed.
Thank you very much. Ms. Stubbs for 3 minutes, and before I ask her to start, I have Ms. Kara as the next 3 minutes for the Liberals. Is that correct? Okay, if somebody could communicate with me somehow or another as to who's the next Liberal questioner, that will be helpful. Meanwhile, I will turn to Ms. Stubbs for 3 minutes.
Thanks, Chair. I just also would agree with our colleagues who invited the witnesses, and I would say both witnesses, to provide any additional written submissions you'd like after this meeting in terms of improving the models, potential options, and any other input you'd like to give to us. Thank you both for being here. Ms. Waugh, as a loved one of a woman who went missing and then was murdered in 2011, I want to thank you for your heroic and tireless advocacy, for your clarity, your conviction, and your resolve. You commented on, you made a comment that I hear frequently from victims' families, and know all too well personally. You said victims are left in the silence, and you talked about the lack of transparency. Could you comment on whether or not you think victims advocates and organizations should have been heard by the joint committee that did the investigation into what happened here, resulting in the murder of Mary Lynn Levesque? And then I invite you to later add whatever other information you wanted to about making sure that victims can be heard.
I think that the victims have to be heard better. You're quite right. I think we need greater transparency, and I would have liked it if organizations such as ours, who accompany families, would have been kept informed of any agreements for compensation for these victims or these families, because as far as this right for compensation, right to compensation that was announced in the charter, unfortunately, if there had been greater transparency, if all this had been made public, I think that many families would have been compensated and better informed of the situation.
Other specific recommendations you would make in terms of honoring the voices and experiences of victims?
Yes, I have several other recommendations. We should set up a public registry to protect families, to better inform families, perhaps if the families were apprised of the psychological reports, they would feel more reassured. Often, these families have very little psychological support. There's very little follow-up done with the families. Just writing an impact statement is difficult, but the correctional service accompanies them, but the National Parole Board, there is no psychological follow-up for these individuals. There's no support when the families are making their declarations or statements.
I just reiterate for those who wish, for either Ms. Campbell or Ms. Bois, who wish to submit further recommendations to the committee, please communicate through the clerk. That will be very helpful. Final 3 minutes, Madame Cara.
Thank you, Chair. Ms. Campbell, if I can just go back to you, and can you maybe talk about what impacts that the changes to the pardon system brought about in 2012, and what impact they have on the ability of people to integrate, and did that affect public safety?
Yes, I would say it did affect public safety. One of the biggest impacts of those changes was the enormous workload pressure it put on the parole board. And requiring a parole board member to make a decision on each and every pardon has drawn those resources away from their regular parole decision making. The parole board has always been under-resourced, and it really put just huge pressure. I think at one point, maybe even still, they were actually running 4 different pardon schemes. The old people who were grandfathered in, the new people, the old gay sex offense mechanism that came in, the drug pardon. It's a huge resource pressure. And that means there isn't the time then to devote to other cases. And it also means that the people who really have done what they were asked to do, which was turn their life around, obey the law, are waiting and waiting and waiting. It means they're not getting a job, they're not doing the traveling, they're not doing what have you. And that's an impact on public safety. Just quickly, a registry of high-risk offenders, the government did that actually quite a few years ago. I don't think it's made one bit of difference to anything, but someday we'll talk about that again. Victims and their role at parole hearings. Yeah, again, it's partly case law. The role of the victim is to explain the harm that was done and any current safety concerns that they have. It's not intended to influence the actual decision. It's very similar to victim impact statements at the time of sentencing. But again, your parliament, and if you want to change that, it's certainly within your purview to do so. I would just say finally that if there is anyone who has not read the 2 parole board decisions or the full inquiry report, which is about 104, 108 pages, I'd very happily email them to you. They're widely available.
Thank you. How much time do I have?
I have about 40 seconds.
Okay, I think Pam is back. Pam, do you want to ask a question?
Thank you very much, and I'm sorry I had to pop away, but my question is for Ms. Campbell. Do you feel that there has been a lot of misinformation put out during these tests? I know you've watched it all, and I'm just wondering your comment on that.
Unfortunately, yes, I feel there has been a lot of misinformation put out. I'm sort of old school, I guess, and very fact-based. Very a researcher at heart, even though I'm a lawyer. And I just think far too often we're hearing people's opinions. I mean, God bless you, you're all entitled to an opinion. Well, I think there was an infamous statement from the south of the border, but you're not entitled to your own set of facts. And you know, part of that then rests on the system. And we've always struggled with that. How do we do a better job of communicating just basic facts about the system to help people understand? You know, we've done a handbook for judges and lawyers, a handbook for victims. We've done this, you know, tried out a TV show.
Yes, unfortunately, we're going to have to terminate both the facts and opinions at this point. Yes, you are entitled to your opinion. You're just not entitled to your facts. I thought that was Churchill rather than, but that commentary certainly applied to President Trump. There's no question about that. With that, I want to thank both witnesses for not only your time here, but your patience with us and your patience with the technology. Thank you for your literally lifetime of service. And it's greatly appreciated by the committee and I think the citizens of Canada. With that, colleagues, the meeting is adjourned.